Hi, good day everyone. I'm Gisby Formentera. We are the Group 1 and the topic that we are assigned to discuss together with my group mates are Chapter 11 and 12. I'll be the one to discuss the Chapter 11, 1-4-1. So this is the Chapter 11, Section 1-4, which is the administrative offenses under Uniform Rules of Procedure before the Administrative Disciplinary Authorities and the Internal Affairs Service of the Philippine National Police. The enumerated and defined administrative cases shall apply to all administrative cases filed against uniformed members of the PNP before the different administrative disciplinary authorities and the Internal Affairs Service. So, Section 1-4-1, General Category of Administrative Offenses. These are the following punishable offenses. So, we have here number 1, neglect of duty or non-feasance. So, it is the omission or refusal without sufficient excuse to perform an act or duty. So, this means that the absence of action to help prevent harm or damage. The penalty of this having of the notice of termination. So example ani non-feasance, wala as a police officer wala ra kay gibuhat imbis na ayon nang inhanglan nimo. Number 2 is the irregularities in the performance of duty or misfeasance. So it is the improper performance of some act which might lawfully done. This means that misfeasance is the act of engaging in an action or duty but failing to perform the duty correctly. So example, ni responde ka og away, then naay nag-away niya, imo silang gikulata aron mohunong sila pag-away. So failing to perform the duty correctly. Number 3, misconduct of malfeasance. So it is any wrongful, improper, or unlawful conduct motivated by premeditated, obstinate, or intentional purpose. It usually refers to the transgression on some established and definite rule of action. So this means that malfeasance is an intentional conduct that is wrongful or unlawful, especially by officials or public employees. So this is the higher level of wrongdoing. The non-feasance, which is the failure to act where there was a duty to act, or misfeasance, which is the conduct that is lawful but inappropriate. Number 4 is incompetence. So it is ignorance or the material lack of adequate ability and fitness for the satisfactory performance of police duties. This refers to any physical, intellectual, psychological, and moral quality, the lack of which substantially incapacitates a person to perform the duties of a police officer. It is so obvious that this means a lack of ability to do something, especially to testify or stand trial, may be caused by various types of disqualification, inability, or unfitness. Number 5, oppression. It imports an act of cruelty, severity, unlawful exaction, domination, or excessive use of authority. The exercise of unlawful powers or other means in depriving an individual of his property or liberty against his will is generally an act of oppression. So example, placing a citizen under false arrest, warrantless searches or warrantless arrest, assault upon a citizen, forcing a citizen to have sex in return, not arresting them. So, giving them a ticket, violations of the civil rights of a citizen, engaging in fraud or theft, and unlawful murder. Number 6 is dishonesty. It is the concealment or distortion of truth in a matter of fact relevant to one's office or connected with the performance of his duties. So dishonesty is a serious offense. It reflects on the person's character and exposes the moral decay which virtually destroys one's honor, virtue, and integrity. The offense of dishonesty is punishable by dismissal. We have here the last number, disloyalty to the government. It consists of the abandonment or renunciation of one's loyalty to the government of the Philippines, or advocating the overthrow of the government through overt or covert acts. So, example, ani kay kuan, rebellion.
Morning everyone, I'm Danding Antagaw and this is my topic. Light offenses, simple neglect of duty. Number 1. Fail to supervise, inspect, and control subordinates directly the command as to their punctually attendance, prescribe attire, proper use and maintenance of equipment, preparation and submission of report, efficient performance of their duties and responsibilities, and the observance of good order, conduct, behavior, and discipline. Number 2. Fail to take corrective actions by way of warning, advice, admonition, suggestions of disciplinary action to subordinate or to report such conduct. When such subordinate is committing or has already committed dereliction, irregularity, or violations of department rules and regulation. Number 3. Fail to order or cause the investigations of a subordinate reported to him as absent without leave. Number 4. Fail to disseminate any order, directive, or instruction. Number 5. Fail to coordinate or cooperate with the law enforcement agencies and their personnel. Number 6. Absent oneself from office without having filed the necessary application for leave or secure the approval of the superior officer for a period not exceeding 3 days in a month. Number 7. Fail or refuse to give his name and badge number when properly requested. Number 8. Fail to report upon declaration of alert levels. Number 9. Fail to report to duty and prescribe uniforms with badge, identification card, service firearm, and other required equipment, except those not required to wear the prescribed uniform by reasons of the exigency of the service. Number 10. Fail to keep an official appointment with a complainant, informer, or crime witness without lawful justification.
Simple irregularity in the performance of duty shall not include but limited to the following. First is drive a marked police vehicle while not in prescribed uniform, except those who are not required to do so by the reason of exigency of the service. So if you are driving police vehicle, you should wear your uniform all the time, except those who have a reason. Use siren or red blinker light while not responding to an emergency or not in hot pursuit of a flaming criminal or law violator. So, dili jud na pwede ang mugamit ka og siren or a blinker while you are not responding an emergency. Third is malinger, loaf, or consort with others while on duty, or arrange with another member to take his place during his tour of duty without prior approval from his superior. So di na nimo biyaan imuhang pwede pistuhan if walay tao nga moabot o ilis nimo. Dapat ug mulakaw mangani ka, mananghid gid kas imuhang taas. Fourth is allow unauthorized member of the PNP to drive marked and unmarked vehicles. Dili pwede padriban ang PNP vehicle if dili sila authorized to drive. Fifth is interfere or obstruct the work of other member or change the assessment or tour of duty of subordinates not belonging to his unit. So, if dili ka labot ang area, so you should not go with them. Wala mo kay labot sa ilang assignment. 6 is arrange with another member to take his post or tour duty with superior approval. So dapat gid ang arrange sila sa ilahang mga gidutihan or ilang pwesto with sa pananghid sa ilahang superior light or simple misconduct shall include but not limited to the following. First, fail to salute official, dignitaries, superior officer, and official entitled to their national colors during playing the national anthem. So failing to salute officials kanang if nakay official you should salute them if masugatan nimo sila. Second is fight, threaten, or quarrel with any member of the police force provided that the member being challenged or threatened with higher rank. The charge shall be that of grave misconduct. So dili bawal gyud na ang mag-away-away sa ilahang kauban na mga police force if musukol sila sa ilahang mga higher rank official kay they will be charged with grave misconduct. Read newspaper, books, predictable while in uniform on street or duty.
Good morning everyone, my name is Jumboy Comeso and my assigned topic is less grave neglect of duty. Simple neglect of duty is a less grave offense, punishable by suspension of 1 month and 1 day to 6 months. Whereas conduct to the best interest of the service, a grave offense is punishable by a suspension of 6 months and 1 day to 1 year. Number 1. Fail to execute lawful orders from higher authority or tolerate any subordinate to ignore or ridicule any order, rule of regulation. Number 2. Fail to comply with any lawful order or instruction of a superior officer or the chief of police. Number 3. Fail to report immediately to his superior officer or the chief of police the injury, illness, death, or escape of a prisoner who is under his custody. 4. Fail to issue traffic citation ticket or TCT or temporary operator's permit or TOP to an offending driver whose license is already confiscated. Number 5. Fail to communicate the chief of police through channels any valuable information that will lead to the apprehension of a wanted person, or furnish clues for the resolution of a case or for the recovery of stolen property. Number 6. Fail to report patrol his beat, sector, or post, or to leave or abandon the same without being properly relieved. Fail to take appropriate action concerning vice condition in the beat and or give written report of the same to his superior. That's all. Thank you.
So good day everyone. My name is Sebastian Tervillas and I'm here to report about the less grave irregularities in the performance of duties. So the first one is apply for and serve a search or seizure warrant in any establishment or private house without knowing knowledge or approval of the chief of police or his superior officer. So this applies if a peace officer was able to serve a search and seizure warrant but were not able to let his superior know that they are in the move. So the second one is use traffic violation reports which are not duly validated by the Land Transportation Office or LTO or the Metro Manila Development Authorities or MMDA or city or municipal government. So an officer needs to only use traffic violation reports which are authenticated by the LTO or MMDA or the municipal government. In short, dili minugna lang na violation. So the third one is the use traffic violation reports duly validated by LTO or city municipal government but are not issued to him for traffic enforcement work. So this is vice versa situation. This is applied when an officer used a verified traffic violation report but it was not issued to the apprehended nor to the LTO office. So, next is the use the official insignia, markings, and seal of the police force in any privately owned vehicle without the authority of Chief of Police, Superior Officer. An official seal has its symbols that corresponds with a different meaning and root, and it must be used for a good purpose and not for tripping only. So the next is disregard or violate traffic rules and regulations while driving a police vehicle when not in a hot pursuit and not responding to emergency call. So this applies when an officer abuses the power and will not follow the traffic rules when they are not in a trailing criminals and is not on emergency. So next is the less grave misconduct. Take advantage of his position by procuring goods and commodities at a loving price to a seller or partake of food, drinks, and cigarettes free of charge. So when a person in authority is using his position to accumulate goods in a lower price and enjoys taking stuffs without paying it. Next is engage in regulated gambling or games of chance while on duty. So this applies when a person in authority is involved or caught in gambling while on duty. So be drunk and disorderly while on off duty, or drunk while on duty and in uniform or in recognizable uniform of the force. So this applies when a person in authority has a high level of alcohol in blood and behaves violently while on off or on duty and is in a uniform. Next is maliciously intrigue against the honor of co-officer or indulge in idle gossip or spreads rumors that tend to discredit a member. So this is when a certain person in authority makes a stain of his co-officer reputation and spread rumors that is unlikely true. So this is more of oral defamation. Next is exhibit marked discourtesy in the course of official duties or use profane or insulting language to any superior officer. So this applies when a person in authority disrespects his superior officer and showed rudeness. So next is serve as escort or security officer whether on foot or by motor vehicle for any private individual regardless of his status in social or religious circles on any occasion unless authorized by the chief of police or the appropriate officials authorized to do so. So this applies when a person in authority serves with a private individuals. Example, Lucio Tan as a security officer without an authorization or appointment from chief of police or high-ranking officials.
Serious neglect of duty shall include but not be limited to the following. Number 1. Fail or refuse to take command in an emergency in order to carry out police duty. Number 2. Fail to prevent or suppress the criminal act of subordinate being committed in his presence or fail to report the same to the chief of police. Number 3. Fail to apprehend and or arrest a person under circumstances which it is his duty to do so. Number 4. Fail to return personal effects of release, prisoners, or other property used in evidence the release of which is ordered by competent authority or court. Number 5. Fail to perform his assigned mission or fail to participate in an operation of the security of president or the high-ranking officials. Number 6. Fail to administer first aid when able and or convey to the hospital victims or traffic accidents, person shot or stabbed. Number 7. Fail to quell a disturbance or to protect a person from death or injury when able to do so. Number 8. Fail to help brother peace officer in apprehending or arresting a violator who resists or in subduing one assaulting the arrest officer. Number 9. Fail to appear and testify in court, prosecutor's office, the PNP disciplinary authorities, appellate bodies, the IES, or any other quasi-judicial. Number 10. Absent oneself from office without having filed the necessary application for leaving or secured approval of the authorized official.
Serious irregularities in the performance of duties shall include but not be limited to the following. 1. Act as a bodyguard or security guard for any public official or candidate for any elective public office or position or any other person within 3 months immediately preceding any election and within 1 month thereafter, without authority from the Commission on Election. 2. Act as a bodyguard or security guard for the person or property of any public official or private person unless approved by the proper authorities concerned. 3. Reveal secret or confidential police matters and information which jeopardize police mission and operation or which cause injury or damage to citizens. 4. Unauthorized establishment of checkpoints and any public thoroughfare for the purpose of stopping or searching vehicles or persons, or if the authorities does not comply with the rules set by PNP. 5. Unauthorized escorting of any vehicle carrying highly dutiable or taxable goods, merchandise, appliances, or machinery. 6. Failure to turn over to the police station within a reasonable period any apprehended or arrested person. 7. Countermand any lawful order of the mayor, chief of police, or superior officer. 8. Perform the duties and function of custom or immigration authorities without paper deputation in accordance with the law. 9. Escort or allow other member to escort detention prisoners outside the jail in order to attend a funeral, visit a sick relative, or solicit a bond without an order of the court or proper jurisdiction.
Grave misconduct shall include but not limited the following. Number 1. Maltreating or abusing someone. 2. Engaging in bribery and having connection with suspects. 3. Refusing to report and doing his duty as a law enforcer. 4. Having a business relationship with whom the PNP officer has business relation. 5. Accepting gift from the preparator, asking for monetary favor. 6. Having a financial transaction with other people with the motive of getting favor of something. Number 7. Controlling the employee's life and impose over superiority to the subordinate. Number 8. Having an affair with other people and being unfaithful to his or her spouse. Number 9. Fails to surrender his or her armor, firearms, badges, and other things that are related to his or her duty during the period suspension. Number 10.
fails to pay the debt may be in a monetary form of service that or she owes in the government.
Oppression. Any member of the police shall Any member of the police force who shall abuse his authority in a tyrannical, cruel, and high-handed manner shall be guilty of his oppression. Meaning ani kay anang prolonged, cruel, or injustice treatment. Example kay kanang mga police nga high ranks, grabe kay sila mo use of power sa ilang mga taw-taw, bata. Kanang mga excessive use of authority. So mo na oppression. Number 4, number 5, incompetence. Gross incompetence. When the offense or negligence is committed by a reason of manifest lack of adequate ability and fitness of the part of the respondent member for the satisfactory performance of police duties, the erring member shall be guilty of gross incompetence, meaning not competent, lacking qualification or ability, incapable, lacking being unable or physical unqualified to undertake or perform police duties. Number 6, disloyalty to the government. Any member of the PNP who shall abandon or renounce his loyalty to the government of the Republic of the Philippines, who shall advocate and overthrow the government through covert or overt acts, shall be guilty of disloyalty to the government. He shall be punished with the maximum penalty of dismissal from the service. Not being loyal or unfaithful to the government of the Philippines. Natigingon si General Lunason nga ito, kalaban ng kakapi. Yung sa una kay kanon to, Philippines versus America. To kalaban ng kalaban. Kontra pag mo yung kagaling ng Pilipino. Man. So, kalaban ng kakampi. Dishonesty. Any member of the police force who shall conceal, alter, or distort the truth in a matter of fact relevant to his office or connected with the performance of his duty shall be guilty of dishonesty. Concealing or distorting the truth as a matter of fact relevant to one's office or related to the discharge of one's duties.
Section 2. Criminal aspects, crimes, offenses, and charges against public officials and employee. As stated, it is fundamental principle in the law on public officers that administrative liability is separate from and independent of criminal liability. So, which means na administrative liability nga na-violate sa public officer kay only sa kana nga liability and separate sa criminal liability. The threefold liability. So, the threefold liability rule holds that the wrongful acts or omission of a public officer may give rise to civil, criminal, and administrative liability, and each independently of others. Thus, an absolution from criminal charge is not a bar to an administrative prosecution or vice versa. Therefore, if napawalang sala sa administrative liability, dili na siya guarantee na wala na kay criminal liability since lahi man sila and maupod sa criminal to administrative, vice versa. Then, this simply means that a public officer may be held civilly, criminally, and administratively liable for a wrongdoing. If the law violated attaches a penal sanction, then the erring public officer may be punished criminally. To secure conviction and prosecution must prove the guilt of the
accused beyond reasonable doubt. So, proof beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof as excluding possibility of error produce absolute certainty. So which means na ang decision sa judge kay dili 100% na sakto. That's why nga naatay mga daghan nga cases na retrial, nga pag retrial kinausab ang decision. So moral certainty is only required, or that degree of proof which produce conviction is an unprejudiced mind. So moral certainty is only required to be fair or unbiased. Then lastly, the accused, if he so chooses, need not to present evidence. He merely has to raise a reasonable doubt and withdraw away from the case of prosecution. The constitutional presumption of innocence demands no less. So, according to Article 66, presumption of innocence, everyone shall be presumed innocent until proven guilt before the court in accordance with the applicable law. So if wala evidence gipresent or mapresent ang accused to defend the accusation, then the judgment will automatically raise to reasonable doubt. So mao na to. Thank you.
Good day everyone, and good day ma'am. My name is Carly Vinbrazo, and my assigned topic is all about the constitutional presumption of innocence. First, concept. In criminal justice system, the overriding consideration is not whether the court doubts the innocence of the accused, but whether it entertains a reasonable doubt as to his guilty. It means that the burden of proving the charge is on the state. This guarantees that guilt cannot be declared until the charge has been proven by the state. Next, purpose. The presumption of innocence is not a mere procedural tool of the law. It is not overcome by the presumption of regularity. Indeed, it can be rebutted only by proof beyond reasonable doubt. It means that it serves to protect individuals who have been accused of committing a crime. The presumption that accused individuals are innocent until proven guilty serve as an important protection in many ways. And third, presumption of innocence versus reasonable doubt versus burden of proof. Presumption of innocence refers to a substantive right in the nature of evidence and is a legal interference growing out of the fact that persons are not generally criminals, while reasonable doubt has reference to the degree of proof required to convict, and the burden of proof is designed merely as a rule of procedure, confers only a temporary benefit upon on him. Presumption of innocence. It means an accused in a criminal case is assumed to be not guilty unless the state can prove beyond a reasonable doubt. Otherwise, it is often difficult to fully grasp this fundamental and crucial concept. Next, reasonable doubt. It means the person suing, called the plaintiff, must prove the case by what is called the preponderance of the evidence, meaning the individual must show it is more likely than not certain facts exist that would entitle the individual to some form of relief. Last, burden of proof. It is the government, not the accused, who is tasked with the attempt to prove guilt beyond a reasonable doubt. If the government cannot meet the strict burden of proof, the accused cannot be convicted, so the burden of proving the case is on the government, but the accused does not have to prove or disprove anything. That's all.
Corollary principles. Number 1. Every circumstance favoring the innocence of an accused should be taken into account. In criminal proceeding, it is required that every circumstance favoring his innocence be duly taken into account. The proof against him must survive the test of reason, and the strongest suspicion must not be permitted to sway judgment. The conscience must be satisfied that on the defendant could be laid the responsibility for the offense charged, that not only did he perpetrate the act but that it amounted to a crime only by proof beyond reasonable doubt, which requires moral certainty. It means the evidence that is beyond reasonable doubt is the standard of evidence required to validate a criminal conviction in most adversarial legal systems. The prosecutor bears the burden of proof and is required to prove their version of events to this standard. This means that the proposition being presented by the prosecution must be proven to the extent that there could be no reasonable doubt in the mind of a reasonable person that the defendant is guilty. Number two, probability of innocence prevails over that of guilt, where the evidence gives rise to two probabilities, one consistent with defendant's innocence and another indicative of his guilt. That which is favorable to the accused should be considered. That every person accused of any crime is considered innocent until proven his guilt. The prosecution must in most cases prove that the accused is guilty beyond reasonable doubt. If reasonable doubt remains, the accused must be acquitted. Number 3. The prosecution must rely on the strength on its own evidence. In criminal cases, the prosecution avers the guilt of the accused, who is presumed to be innocent until the contrary is proved. Therefore, the prosecution must prove such guilt by establishing the existence of all the elements of the crime charge. For example, the information accused, namely Roberto, attempting to sell, deliver, give away to another, and distribute the 3 kilos of marijuana, a prohibited drug, well knowing that the sale, delivery, and distribution to another of such drug is prohibited. The prosecution must rely on the strength of its own evidence, not on the weakness of the defense. Clearly, one of the elements of the offense is that the accused knowingly delivered a dangerous drug to another. We hold that the guilt of appellant Roberto has not been established beyond reasonable doubt. Wherefore, for lack of proof of his guilt beyond reasonable doubt, Roberto is hereby acquitted of the crime charge. That a defendant is not guilty of the crime charge. Rather, it means that the prosecutor failed to prove that the defendant was guilty beyond reasonable doubt. That's all. Thank you.
Crimes and abuses committed by public officers under the revised penal code. So, introduction. The definition of this is the public officer's site in jurisprudence. It is the authority of law which is provided by Mitcham. The public officer is the right, authority, and duty created and conferred by the law. They are the one who make judge for the benefits of the public. The characteristic of the public officer must be delegation of sovereign function, which is the state is not answerable before the court of the law of their performance.
Good morning, Miss. Good morning, classmates. This my topic is about crimes and abuses committed by public officers under the revised penal code. In crimes or offense committed by public officer, one of their indispensable elements is that the offender by a public officer or employee, or the offense cannot exist without the officer or be intimately connected with the office and perpetuated while the officer is in the performance of his office. To be in public office, compensation is usual but not necessary criterion. office is public office. Nonetheless, delegation of sovereign function is the most important characteristic of a public officer. Good morning and thank you.